My Lord, in response to the two applications, yours also an application. Yes, my Lord, in response to the application by my learned friend, Mr. Ochiel, future senior counsel, and my learned friend, Mr. Ndegwa, I wish to set as follows, my Lord. My Lord, number one, the Matthew paper order sought by my learned friend fall on the basis of the following principles. Number one, my Lord, there is already an appeal that has been filed in the Court of Appeal, and an application for stay under Rule 5 to be filed, being application number 554 of 2024. The Court of Appeal is therefore seized of this matter, already seized of this matter. In those circumstances, my Lord, a party can only apply for stay in the Court of Appeal. That's point number one. My Lord, point number two, ordinarily, when a court delivers a ruling in a matter, the court becomes functus officio in respect of that particular matter. My Lord, that matter therefore, or the applications made are therefore res judicata, in the sense that a determination has been made, and this court cannot go back and approbate and reprobate at the same time. You cannot deny an order and then purport to issue the order again. Point number three, my Lord. My Lord, rules 23 and 24 of the Mutunga rules as presented before you, together with an application by my learned friend on substantive issues touching on actions that may be undertaken subsequent to this, including, my Lord, the qualifications of the Deputy President nominee, Kindiki, can only be brought to this court, my Lord, through one, either a new petition and a new application, or two, my Lord, through an application for review. The only avenue that Mr. Ndegwa can bring all the issues that he has spoken to this afternoon are applications through review. No application for review or setting aside has been filed before this court by Mr. Ndegwa. And therefore it is inconceivable, my Lord, that this court would entertain the application brought on several grounds, my Lord, including grounds challenging the suitability or otherwise of the Deputy President nominee. My Lord, lastly, and because my learned friend will submit further, once a court has delivered a ruling, my Lord, the justice of the cause is that consequential processes can be undertaken given that there are no orders in place. And that is not for the court to be part of or to control. That is for other parties, probably not before this court, my Lord. My Lord, what you have done is dismissed the application conservative order. So that's a negative order. The court cannot be invited to review or to stay a negative order that has dismissed an application. And the negative order again goes to the application by Kimotho and Company Advocates from Kerugoya, who has also sought to stay your orders, yet all that application had, my Lord, was for the former Deputy President, former underlined, to apologize to NIS. Surely, Kimotho, you can do better. My Lord, I'll invite my learned friend to go.
You are protected. You are protected.
No, Mrs. Kimotho and Company.
Yes, my Lord, my name is Muzomi Kenkolu for the second interested party. I have listened very keenly to the two applications, and the issues for you to weigh in your mind are as follows. One, if the outcome they seek through these two applications was declined by the Court of Appeal not yesterday, but today morning, can this court, being a court lower than the Court of Appeal, on the very same day be seized of an application that result in the very
Your
outcome?
Lordship, may I kindly bring it to your attention that counsel has a duty to this court to speak the truth. Being an officer of this court, being a doctor and a teacher of the law, he understands the duty that he has towards you and towards the law and the fidelity to the law. It is not true that an application was dismissed. It is true that parties were told to serve. So let him submit on the premises of facts and not the premises of presumptions and with the intentions to mislead this court. And if it was declined, let him bring the orders.
My lord, I think it's an issue of semantics. I come from a community that is not an expert in the English language, but whatever you call it, the point is this. The effect of you granting either of the two applications would be to contradict a decision by the Court of Appeal today morning, not to grant similar applications. That cannot be denied in good faith.
We are objecting to this. They are misleading. I was before the Court of Appeal.
You were in a car. You were in a car in the morning.
My lord, the Court of Appeal is a court of record. I don't want to believe at this point. Let me move to my next point. The Court of Appeal is a court of record, and I'm sure the court has access to that record. Two, my lord, it is not like Kindiki was nominated yesterday or the day before yesterday. He was nominated several days ago. If the applications now being made were made in good faith, they should have made a formal application several days ago, which would have been on record, which we would have had the opportunity to respond to. You are now being invited by submissions from the bar without a formal application to grant some relief, supposedly on the ground that Kindiki'S and suitable. That cannot be proper, my lord, especially when the nomination of Kindiki wasn't made yesterday or last night. They had noticed for several days. If they have any issues with the suitability, they would have filed an application on that regard, or even amended. The applications were just determined and they were granted that leave, and they didn't amend them. So surely it's an ambush for my colleagues now to stand up and start telling you Kindiki this, Kindiki that, and therefore stay, and therefore Matthew paper this and that. Two. Number three, my lord, what you're being asked to do is to flip-flop or to behave like a pendulum. My lord, a pendulum moves from this end to the other end, but it never leaves the two extremes, so there is what I usually call motion without movement. The court has already read a ruling to us saying that it cannot issue a conservatory order that would have the effect of suspending any provision of the Constitution. You're being invited right now to do exactly what you have just told us cannot be done, and you're told the reason you should do that is because you're human and there is a possibility you're in error. Of course there is a possibility, my lords, you're in error, but there is a court that exists to correct errors made by this court. You're being asked to embarrass yourself to say just a few minutes ago that the conservatory order should not have issued in the first place, and then you're being invited to issue an order that would have the contrary effect. I think they are setting up the court for embarrassment. My lord, there is a reason, there is a law which we all know because both the people in the bench and the bar are lawyers. And it is common ground that no appeal operates automatically as a stay of any decision made by any court. The reason that rule exists, my lord, is so that whoever is desirous of an appeal can move the appropriate court, which they have done, and persuade that appropriate court to issue that stay. So they are telling you, because there is a possibility you might be in error, therefore automatically the rule, if I understand it, is that no appeal, let alone an intention to appeal, can issue automatically. Lastly, my lord, you have been told about a Madhupepa injunction. I thought we were talking about conservatory orders, my lord, because Munya told us injunctions are remedies in the realm of private law. They exist to protect personal private interests, and conservatory orders, which you just said cannot issue in the circumstances of this case, are the remedies available in public law for the ordered functioning of public agencies. And because, my lord, I said this court has jurisdiction, if eventually you find that the Honorable Rigathi Gachagua was not lawfully impeached, this court has still confirmed it has a remedy. It can undo the entire process. Let us not detain you here, back and forth, flip-flopping, behaving like a bedlam. It is holding the court at ransom, in my view.
My lord, if I use only 2 minutes in rejoinder, the court permit me.
You will respond after Peter.
Yeah. My lord, I'll just take 2 minutes to mention something which will be in addition to our case. My lord, Article 10 of the Constitution outlines the doctrine of rule of law. My lord and my lady, the doctrine of rule of law anticipates that at some point controversies in the society, especially legal controversies or controversies related to the interpretation of the Constitution, will be determined by judges. And concomitant to that is the doctrine of finality of your decisions. And more importantly, the public policy in terms of consistency in judicial decision making. So, my lord, my lady, once you've made a decision, the expectation of the public is that you will stand by that decision unless there are exceptional reasons for you to depart from that decision. Especially immediately after you've rendered your decision, it will undermine that doctrine of finality of judicial decision making if you immediately depart from the decision without exceptional reasons. They have not put on record exceptional decisions to warrant that immediate departure, and the public expects that your decision will be enforced. Secondly, the doctrine of rule of law again operates in a complete way. John Locke in 1689 developed a concept in his treatise of government known as the concept of inalienable right, which informs our constitution. And one can mention here that judges have a right to be wrong. They say you have a right to be wrong. We have listened to your decision, and we believe that the reason why conservatory orders cannot be continue is a heavy public interest reason of the need for the vacancy, for there to be no vacancy in the office of deputy president. And the Constitution does not anticipate that. So in conclusion, they, under the provisions of Article 164(3), they, based on the way the rule of law works to model the fabric of the society, they have the right to appeal. My lord, you have granted that right in your ruling. And from where we stand, we submit that they cannot, on this matter of immense public interest, where you've made a decision for them to seek, to make an application from the bar, to upset a decision which you have rightly pointed out is meant to fill a major constitutional gap in respect to vacancy. And lastly, the right to be heard. The right to be heard is very central. Mr. Ndegwa has made factual statements in this matter in his oral application. Again, given the immense nature of this matter in terms of public interest connotations, it is important that the respondents are given opportunity to specifically rebut the factual questions of law, the factual questions and some of the legal points that they are brought up. So in that case, if they really want to move this court, then we will submit that the proper way is to make a formal application so that we are hard on that question. Thank you.
Your Lordship, the IEBC, the second application was directed at us. Everyone seems to have said something except the IEBC. And I just want to make two small points. Number one, as it relates to the application by Mr. Ochiel Dudley, my friend. First, Madhu paper was pre-2010 constitution. That is important for the court. It was a commercial matter relating to restitution. So it was a remedy in private law, not in public law. Lordship, Madhu paper was pre-2010 constitution. It was a commercial matter, a restitution in private law. So this will not apply. The second issue, application by Mr. Ndegwa, Learned Counsel, I am looking forward to reading the decision of the court, because those were issues that we were on our feet for 30 minutes arguing about, the role of IEBC and what needs to happen. So already the court has made a decision on that, and likely the answer will be in the ruling that the court has already read. Third one, and most importantly, I want to point to the court the case of Eliud Matindi and two others versus the President of the Republic and the PSC, E084 of 2023. It is the CAS matter. And it feels almost like deja vu that Ochiel Dudley is here making this point. We lost that matter in the High Court. The court made a finding that the offices of CAS were not constitutional office. We were on our feet for a long time trying to urge the court to give us a Madhu paper injunction. And the court said, if the issue related to constitutional compliance or constitutional infraction, as the court has already noted, that the position of the Constitution must remain operational from the decision of this court, then that injunction will not apply. The remedy is for the parties to apply to the Court of Appeal for an appeal or a review of that decision. So those three things can clarify those two issues for the court. We think these applications are not merited, and the court and the parties should put more effort in their 5-2B application. Thank you.
Perhaps before senior speaks, maybe we get directions as to how many they are responding, because there was that limitation on this side, and we were restricted as the petitioners. If the court could give directions as to that.
Let Mr. Moses speak.
Thank you, my lord.
My lord, but you have not given us directions as to how many of them should address you, considering that the petitioners were restricted.
We said two. 3 of them have already spoken.
My lord.
Mr. Moses, nothing stops you from saying that you adopt the position of your predecessor.
That's correct.
Yes.
My lord, I want to say that I associate myself with the sentiments by my colleagues, but I would want to add, my lord, that you have given a detailed and a very comprehensive analysis of your ruling. You've gone into graphic details, and you have addressed various issues and given a determination on the same. We are not before this court, my lord, to litigate in installments. My learned colleague, Mr. Ndegwa, has all along been aware that Professor Kindiki was nominated. For him to just spring up now and start raising issues concerning Professor Kindiki is just but a mockery of the justice system. My lord, you've made a determination. You have thanked us official. We will not want you to reopen these proceedings again. They have known and available avenues to them. Let them proceed on those avenues. I submit, my lord.
Thank you very much. On only one point, which I actually objected to when it was being made, the point was that how would Kenyans receive the decision? I'm not so sure whether this is what these applications should be based on, because whichever way, there will be parties that will be aggrieved by the decision. There are many others that will be satisfied. Do not be misled that there would be protests, just the way I also cannot mislead you by saying there will be jubilation and celebration everywhere. The position remains, the court has rendered itself in a decision, the court is functus, and therefore we have now to move on. Any party aggrieved knows what to do, which is either to appeal, apply for a review, variation, or whatever it is they have to apply for. If the processes that will take place after this would be contra the Constitution, every party knows what to do, and this court is still seized of the matter, and they will be coming over here for a pronunciation on what the constitutional rights are. Therefore, we should actually not be taking the route that the decision may be popular or unpopular. It's a decision of the court, and it cannot be challenged along those lines.
Thank you. My Lord, honoring the court and my colleagues' time, this is my rejoinder in exactly 2 minutes. My Lord, Rule 32.2 of the Mutunga rules allows us to make this application informally as we make it. Rule 32.2 of the Mutunga rules allows us to make a Madhu paper application as we do. It says the application can be made informally immediately after delivery of the judgment. Rule 32.2 Mutunga rules. My Lord, this President, the Attorney General, when on the other side, has many times sought a Madhu paper injunction. In the Finance Act litigation, where my friend Mr. Somane was present, Justice Majanja presiding, this court in this room issued a Madhu paper injunction. My Lord, on the last point, my learned friend Mr. Ojenda sounds familiar with the Madhu paper case. It's a Court of Appeal decision. And you saw the first one, Bat versus Rent Tribunal. It is one of the most cited cases on the question of stay. And in that case, the Court of Appeal said, my Lord, allow me to read, and then I'll sit down. There is no inconsistency in granting such an injunction, a Madhu paper injunction, after dismissing the motion. The purpose of the order is to prevent the Court of Appeal's decision from being rendered nugatory, should that court reverse the High Court's decision. The respondents concede that you could be wrong. There's human infallibility. The purpose of the request we make is to respect that issue. What if you are wrong? And you allow the wrong person to come into the high office if just established. My Lord, allow the request for 7 days. Thank you so much, my Lord. And my Lord, may I just clarify that our application is distinct. We do not seek stay, we seek an injunction. Thank you.
And I'm interested, in the event, my lord, it's allowed, can we also move you again to